America's abortion debate, and I use that word advisedly, is insane. It's been insane for years. It's been insane for decades. It's been insane at least since the passage of Roe v. Wade. So I'm naturally a little bit wary about bothering to involve myself in it. But being an opinionated bastard, I thought I'd chip in anyway with a couple of points to make. In the first place, Roe v. Wade should be overturned, and this is true regardless of where one stands, where I stand even, on the question of abortion. It should be overturned because it is bad law. It should be overturned because it is not the federal government's job to decide these matters. It should be overturned because the federal government has been given the power to decide these matters. It's been elevated to the status of constitutional right, therefore denying people the ability to express their actual opinions at the ballot box. This always makes political extremism more likely. This should never have been an argument for the courts to decide. If pro-choice campaigners or pro-life campaigners are so confident that their positions have majority support, you can test that at the ballot box and elect a government in your state that will approve or disapprove of your position. Very simple. So that would be a meta point worth considering. In the second place, overturning Roe v. Wade would not, despite the hysterical reports to the contrary, end the right to abortion. Roe v. Wade is not your guarantee of a right to abortion. It didn't create, it attempted to create a right to abortion, a federal right to abortion. But these rights predate Roe v. Wade. States previously set their own abortion laws. There were very few federal restrictions in place. States where there was a majority support for pro-choice positions had very liberal abortion laws, and states where the populace didn't support those things tended to be more pro-life. This is the natural way of things. So many problems in American politics today come because states' rights have been so terribly eroded that people in New York believe it is their right to set policy on issues of conscience as well as on issues of politics on behalf of people in the South. To an extent, vice versa. But by and large, people in the South are more keen on states' rights, individual rights for individual states, less keen to say what happens in Alabama must happen in Manhattan. It's a particularly northern progressive democratic problem, this. So that's something to bear in mind as well. You're not having your right to abortion taken away if Roe v. Wade is overturned. If your state doesn't want abortions, move to a state that does. If your state wants abortions and you think it's morally bad, so bad that you can't possibly live alongside people who think that it's right, move. Great thing about living in the United States, you can move. Quite easy. You would have to cross state lines to do it, though, which maybe is why Democrats are so unhappy about the prospect, because, of course, crossing state lines for any purpose is, for some reason, illegal now. At least it has been since Rittenhouse, for dubious reasons. But I don't think I even need to tell you what my position on abortion is. It's not relevant. Those things are true, regardless of what one thinks or believes about the morality or otherwise of abortion. So no, I'm not even going to tell you what my opinion is. I'm just going to go through it and actually attempt to impart some relatively dispassionate information as opposed to the hysterical mudslinging, which, curiously enough, and as we'll come on to see, is completely unrepresentative of the actual split in America, for instance, between men and women, who broadly think along the same lines as regard abortion. Again, will come as news to progressives that, roughly speaking, half of all women and half of all men describe themselves as pro-life. It's not a gendered split issue. It's a roughly 50-50 split nationally on both genders between those two positions. And again, the natural way of doing these things is to decide it at the ballot box, where you can vent your emotions and elect a government which will represent your interests. That's how to manage this issue. The reason America's abortion debate is so hysterically effed now is precisely because people have had the right taken away from them to decide what should pass for morality or immorality in their own individual lives, in their own individual states. But again, I have to point out as well, regardless of one's own position on abortion, most of the lies and most of the hysteria is objectively coming from one side of this debate, not the other. Again, as we'll come on to see. But background first, commentary later. Well, more commentary later. As NPR reports, the future of Roe v. Wade is in doubt. The Supreme Court is hearing on this matter at the moment. It mistakenly says that the right to an abortion in the United States appears to be on shaky ground. Again, it's not, but that's what they're passing it as. Which is, again, one of the reasons there's so much hysteria, because the issue has been inflated to a level of severity it does not, in fact, deserve. But at issue in Wednesday's case, which is Jobs v. Jackson Women's Health Organization, is a Mississippi law that would ban abortion after 15 weeks of pregnancy. We'll go on to the Mississippi law in a bit more detail shortly, but NPR's summary continues that until now, All the court's abortion decisions have upheld Roe's central framework that women have a constitutional right to an abortion in the first 2 trimesters of pregnancy, when a fetus is unable to survive outside the womb, which is roughly 24 weeks. But Mississippi has asked the Supreme Court to reverse all its prior abortion decisions and return the abortion question to the states. Sensible. Good idea. That's what it should do. There is no argument that the people in New York should be able to impose their morality on the people in the South. This is the death of federalism. This is why United States politics is so completely screwed. Government has become so big, issues have become so centralized, states' rights have been so diminished, that every single issue of conscience becomes a national issue. And the only way you can do it is by campaigning to try and sway justices, rather than electing politicians, which is the way you should go about it. Anyway, the court's 3 newest justices, which is Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett, they're all Trump appointees, NPR is obliged to point out, appeared to signal they're ready to side with Mississippi, but it wasn't immediately clear if all of them would strike down Roe. As the state of Mississippi has asked, there is a moderated position, which is one that they might go for as a compromise position. The new 6-justice conservative supermajority seemed to fall into 2 camps, NPR reports. In one were Justices Clarence Thomas, Samuel Alito, and Gorsuch, apparently willing to reverse Roe entirely. Perhaps other decisions based on the right to privacy, which doesn't exist. It's not in the Constitution. Well, I'm going to come on to that. And in the other camp, the court's other 3 conservatives who were reluctant to go beyond abortion. Even on abortion, there appear to be some divisions. NPR continued, the question being whether dismembering the court's abortion jurisprudence would be a one-step dance, outright reversal, or something short of that, a more 2-step or 3-step dance that would play out over several years. Chief Justice John Roberts, a fellow conservative, focused on abortion only and on the viability line, not on reversal. Interested in why 15 weeks, for instance, is an inappropriate line, as Mississippi contends that it is. The counter-argument from the opponents is that if the court were to move the line substantially backwards and 15 weeks is 9 weeks before viability, Your Honour, it may need to reconsider the rules around regulations, because if it's cutting the time period to obtain an abortion roughly in half, then those barriers are going to be much more important. Yeah, changing the law requires changing the law. Staggering revelation. Alito said that the fetus has an interest in having a life. That doesn't change. Oh, that was another thing I meant to mention at the outset. Some of the another of the great problems is the degree to which people talk past each other. So you will see Democrats on Twitter, and we might come on to a few of them, focusing solely on a woman's right to choose. For instance, women's healthcare options was one particularly colourful euphemism, or rather bland euphemism that has been deployed. Missing the point, rather, which is that if your contention is that a child is a child, then women's rights, presumably, should extend to the rights of girls in the womb, no? Are you not denying women's rights by saying that some women have the right to terminate other women's rights? That seems to be at least an argument that should be addressed. The problem is that these arguments aren't even being addressed. They're being ignored in favour of procedural arguments in court, and screamed about by irrational idiots outside the court. That doesn't help anyone. But again, you're going to have to address points like this. It's not enough just to say that it's a healthcare option. Well, I think a fairly sensible response to that is that children are not a healthcare option. Anyway, as NPR continues, Justice Kavanaugh, who replaced Justice Anthony Kennedy, a more centrist justice on abortion questions, signaled he may well be willing to reverse Roe. Nodding to the court's precedents, he said that when it comes to abortion, there are 2 interests: the woman's right to terminate a pregnancy and the interest of fetal life. The problem is you can't accommodate both interests, you have to pick, he said. Well, only if you draw a distinction, but why should this court be the arbiter rather than Congress, state legislatures, state supreme courts, and people being able to resolve this? Good point. The court's liberals, by which we mean leftists, quoted from the court's previous decisions on abortion and the liberty interest enshrined in those decisions, which does not extend to unborn children. What has changed? Asked Justice Sonia Sotomayor, noting that the state of Mississippi in enacting the ban on abortions after 15 weeks cited the change in the court's membership. Will this institution survive the stench that this creates in the public perception that the Constitution and its reading is political act, she asks. Well, no, but that's what Roe v. Wade was. Roe v. Wade creates, invents, fabricates a right to privacy out of, I believe, the Second Amendment. Or was it the Fifth? I think it's the Second Amendment, Second or Fifth, which is not in the text of the Constitution. It's never been in the text of the Constitution. The original argument was a terrible argument. It made no legal sense. And it's not just conservatives who said this, who thought this, who believed this, because Ruth Bader Ginsberg famously wasn't a very big was not a very big fan of this either. As New York Times again separately reports back in 2020, she wasn't really fond of Roe v. Wade. She didn't like how it was structured. She thought it was a bad legal argument. The ruling, she noted, in a lecture to New York University in 1992, tried to do too much too fast. It essentially made every abortion restriction in the country at the time illegal in one fell swoop, leaving it open to attacks. Doctrinal limbs too swiftly shaped, she said, may prove unstable, which it evidently has. This decision has wrecked American politics. It's made the... Sotomayor says that reversing this decision will give the impression that the court is politically involved. But the decision in the first place ensured that the court was politically involved. Reversing this and reverting to states' rights and the ability of the people to elect governments, politicians who will decide these matters on their behalf as their representatives, is to remove the court from a hot-button political issue. That's just obvious. Where Sotomayor got her awful attempt at a rebuttal from. This is a person you're supposed to trust as a part of the Supreme Court who makes arguments as shoddy as that. I mean, that's quite something. But anyway, the New York Times continued here that it was because of her early criticism of one of the most consequential rulings for American women that some feminist activists were initially suspicious of her when President Bill Clinton nominated her for the Supreme Court in 1993, worried she wouldn't protect the decision. They eventually realized Justice Ginsburg's skepticism of Roe v. Wade wasn't driven by disapproval of abortion access, but by a wholehearted commitment to it. Which, again, you can disagree with Ginsburg's position on the morality of abortion, but again, it's a question of procedure. Law follows procedure, must follow procedure if it's to stand any chance of surviving the winds of politics. And Ginsburg was right to be skeptical of Roe v. Wade, precisely because it was a terribly argued decision that invented a right that does not exist in the Constitution, which is now the basis of unlettered claims from activists and screaming feminists and women and their male supporters in Congress, Democrats invariably, about a constitutional right to abortion that does not exist. Even under Roe v. Wade, it does not exist. There is no constitutional right to an abortion. And if you do these things, if you muck up the procedure, you don't even get clarity on that point, which is what allows shamelessly dishonest creeps to make shamelessly dishonest, creepy arguments. But Ginsburg believed it would have been better to approach it under the Equal Protection Clause, because that would have made Roe v. Wade less vulnerable to attacks in the years after it was decided. Professor Hartnett, who was her, I think, official biographer, said she and her co-author on the biography, Professor Wendy Williams, spent the last 17 years interviewing Ginsburg for the book, though initially didn't have a release, etc. In a way, Justice Ginsburg's opinion on Roe perfectly encapsulated how she functioned. She was passionate about equality for women, LGBTQ people, minority groups, fiercely devoted to human dignity and respect, etc. But she was also deeply thoughtful and measured on how to bring those conditions about. Yes, because if you can be as passionate as you like, but good intentions pave the road to hell, your good intentions must be backed up by proper respect for law and the procedures of law, and the demarcation of powers, the division of powers, the separation of powers, and the conflicting powers of American institutions, all of which Democrats in particular have completely forgotten about. Republicans do this too, more often in the past than now. But now, almost all of this is coming from the Democrats. I don't support either party. I wouldn't vote for either party. I wouldn't vote for any of the candidates for either party. I'm not a political partisan in that respect. It is, as far as I can tell, objectively the case that most of the shoddy arguments, the lies, the screaming, the misleading statements, the fabrications, the deliberate untruths are all coming principally from one side in this particular divide. During the same term that Roe v. Wade was decided, the article continues, Justice Ginsburg was preparing to appear before the court on the other side of the bench. In that case, Captain Struck, an Air Force nurse who was stationed in Vietnam, had become pregnant. She was given two choices, to have an abortion or leave the military. Before Roe, though abortion was prohibited in most states, it was allowed on military bases. Yes, it was also allowed across the North. There were some very strict limits in place in the occasional southern state that allowed it. But this is how federalism is supposed to work. It is not one rule across the entirety of the United States. That is the opposite of what the founders intended. They structured the country in a specific way precisely so. Metropolitan cities in the North could not impose their will upon the South, because if they were to do that, the Union would not hold. So there's another sense in which this political overreach and the politicization of the court is a real and present threat, to borrow a phrase from a previous Supreme Court justice, to the future of the American Union. Because you're doing the opposite of what the founders set the country up to do. And you're reaping the results that they knew would happen if they set it up in any other way. What is that quote about people who don't remember the past being doomed to repeat it? Ginsburg thought that the Struck case would have provided a stronger foundation for a woman's right to choose, tried to see if Captain Struck would find other instances of discrimination to keep the case alive. client focus, etc. Another of her unexpected opinions came earlier in the year. Virginia became the 38th century equal rights amendment, etc. Ginsburg took some. She was by and large, I think, not somebody I would agree with politically, but nevertheless was a very clear, very intelligent, interesting, morally serious human being with a proper respect for procedures, not just what we want to get done, but how it should be done properly. Something again that we've by and large lost sight of, regrettably. Here's the some of the polling data I mentioned earlier. The impression is often given that this is men trying to impose their will on women. This is the line that many Democrats will take. It's the one they'll tell you is the case. It's a sexist society which attempts to restrict abortions. Increasingly, they've started to... So everything nowadays that they don't like is a threat to democracy. So you've had people coming out saying that we don't even live in a democracy if abortion is restricted in any way in any of the states at all. No, you don't live in a democracy if your Supreme Court decides this matter and the states have to comply. That's opposite land. So this is Gallup polling from 2021. This sort of fluctuates a little bit depending on which poll you look at, at which time of year and in which year, but it doesn't fluctuate a huge amount. The balance is always pretty roughly split. I mean, as you can see here, this is the 2021, which was taken from a sample of only 1,000 people from Gallup. So again, depends on the study you're looking at. But other studies bear this out as well with larger sample sizes. So that's not a point against it. Of the 1,000 people they interviewed, men were 50% pro-life, 45% pro-choice. Women were 52% pro-choice, 43% pro-life. This doesn't really change very much. I mean, they go back through a few years. This is 2020. Men were 43% pro-choice, 51% pro-life. Women 41. Very little change. If you go back to 2019, men were 48% pro-choice, 46% pro-life. Women 43% pro-choice, 51% pro-life. There's a reversal of the position, but again, given how tight the numbers are anyway, reversals are likely to happen. 2018. Men, 47% pro-choice, 49% pro-life. Women, 48% pro-choice, 47% pro-life. To back up my point about this doesn't really matter which poll you choose. Now, this is from Vox, but then again, you could argue this is evidence against interest, given Vox's usual stance on abortion, but even Vox has to admit that men and women have similar views. It did a polling project with Perry Undum, tried to capture the full nuance of Americans' views on abortions, and one of the things it showed is that Americans do not understand broad ideological terms like pro-life or pro-choice in rigid ways, or even necessarily see them as mutually exclusive. And we're going to close, hopefully presently, with at least one suggestion for a compromise. If you are going to have a federal solution, it must by definition be a compromise. You cannot give one side all of what they want, because that way lies ruin. But again, the best way of doing this is just to defer to states. But as you can see here, almost 50-50 splits between men and women being pro-choice. In this poll, women actually slightly are more likely than men to describe themselves as pro-life. Again, not something you usually hear from the narrative that's peddled to you on mainstream media, which presents this as a battle of the sexes. Quite a few polls throughout history show that women are slightly more in favour of abortion restrictions than men are, for fairly sensible reasons, and biological reasons too. But of course, we're supposed to pretend that those don't exist. Now, I mentioned that it wrecks American political discourse by attempting to remove things from politics. We in the United Kingdom have good experience of this. One of the reasons the Brexit debate was so vituperative, vociferous, nasty, was because for 40 years you'd had a process of removing politics from the people. We'd had referendums on things promised to us for decade after decade after decade and never delivered. And that 40 years was a constant stream of sovereignty seeping away from Westminster, and so away from our elected representatives, and so then away from the people who elect their representatives, toward an unelectable, unaccountable, supranational body in Brussels. And this creates a huge amount of resentment, because there is no natural outlet for people's views. You can't vote then to have your preferred policy idea, your preferred moral idea tested at the ballot box. You can't have it enacted in proper ways. It is superimposed upon you whether you like it or not. And on issues of conscience, which are split very closely down the middle, you are essentially telling half the people in the country that their views, their morality, their conscience is worth not only less than the other half of the country, it is worth nothing compared to the other half of the country. This is why people get so riled up about this kind of stuff. And it's why it should be returned to a democratic process, not placed in the Supreme Court, where nobody can get at it. If you want to actually solve this issue, states' rights is the solution. And America has been trending for years, for decades even, away from that fundamental principle of federalism, trying to become a more unitary state than it was ever designed to be, and you are now reaping the whirlwind. But the hysteria, of course, comes from many different sides. Here we have well, okay, you can be in favour of abortion, for instance, in any circumstance at all, in some circumstances only, in theory, in practice, whatever. You can be in favour of abortion without celebrating abortion. Celebrating abortion is sick. There is no other way of putting that. It is just sick. Because if you don't think you're ending a life, you are ending a potential life. You are making a significant decision for yourself, and if you believe that children in the womb are children, a significant decision to end another person. But whatever your position on this, it is a serious moral question, not something frivolous, as these women who are celebrating allegedly at least taking abortion pills, they claim they are, outside the court building, celebrating it. Don't ever believe anyone who tells you that, well, of course, abortion is a moral issue, that's why we support it, who then has nothing to say on stuff like this, because they are lying to you. But this is another aspect of because the polarization happens on both sides. By definition, it is polarization. So the more angry Republicans get about liberalized abortion laws or leftist abortion laws, the more insane the Democrats get when there's any hint of a threat to their monopoly on legal power or political power. This is not just a case in abortion, it's a case in elections. That's why everything is a threat to democracy if they don't like it. But this is a classic example of this. This is not sane behavior. This is not moral behavior. This isn't serious behavior. Remember when Bill Clinton said that his position on abortion is that it should have been safe, legal, and rare? I don't like Bill Clinton. I have nothing good to say about Clinton, but that was a compromised position. It should be safe, it should be legal, but it should be rare. The rarity part, acknowledging that it is a serious moral thing, it is a serious moral act. It is an act with the most profound of consequences. And that doesn't rely on you thinking that unborn children are children, or whether they're just lumps in a uterus. Either way, it is a serious moral issue. And here we have people there aren't really words to describe it, but they're not alone. They're not alone. You see euphemisms deployed by people who are ostensibly more sane. You get the reaction of elected politicians, people who say that they want to codify Roe v. Wade into law, for instance, spurred into action by the potential threat to a non-existent constitutional right. It shouldn't be federal. It's better having it as federal law than as Supreme Court diktat. That's fine. But this sudden urge to codify Roe v. Wade into law is based on the presupposition that the right to abortion ends without Roe v. Wade, and there has to be a federal allowance for abortion, which is precisely the issue under debate. So actually federal law, though better because it's at least somewhat closer to the people, is not so much closer to the people as to be acceptable. It still affords the federal government way too much power over issues of conscience that should be devolved to the local level as much as is possible. You get the usual crud from a reverend. You'd think a Christian of all people. But no one should be able to mandate what a woman does with her body. I don't know the last time Reverend Raphael Warnock familiarized himself with his Bible or the theology of his church. But traditionally, and I'm not a Christian, I'm an atheist, I do not have much time for Christianity at all, but traditionally, the Christian position is that, life begins from conception. It's not just a woman's body. It's not just a woman doing something with her body. By definition, if you take that view, which you're supposed to if you are a Christian, this is why Joe Biden gets in trouble when he tries to take communion. By definition, you are doing something to other people's bodies. You are killing somebody else in the name of your healthcare options. And it is a pseudo-religious position. As reported by Carl Griffin, Lieutenant Governor Fetterman of Pennsylvania said that Roe v. Wade is sacred. The right to an abortion is non-negotiable. We can't let McConnell's Supreme Court decide the fate of abortion. It's not gonna. The whole point of the Mississippi law is to revert the decision to the states. The point is to get the court to abnegate responsibility for the issue of abortion. But again, radical propositions to solve it, Democrats in the Senate must immediately scrap the filibuster and pass the Women's Health Protection Act. Good luck with that, with a 50-50 Senate. Yeah, that's going to work well. SCOTUS overturning Roe v. Wade won't be America's first time denying women their reproductive autonomy, this person says. Thousands of Native women were subject to forced sterilizations. Yet, that's not in any way analogous. How is that analogous? The state isn't forcing you to carry a child to term. It's simply saying that if you even in Mississippi, even in the deep South, where they do want quite strict lines, the lines are still 15 weeks, I believe. It's not forcing a decision. You've got 15 weeks to make a decision. 15 weeks to decide whether you're going to end or keep a life. Or if you prefer, whether you're going to eject a bundle of cells or not. But of course, at the moment, I think it's up to 25 weeks. It's significantly more than a bundle of cells by the time you're legally allowed to abort it. Codifying Roe v. Wade is again the overwhelming. Women's healthcare is not murdering a baby in the womb, says Marjorie Taylor Greene. I hate agreeing with her. I'm not sure I fully do on that position. I'm not going to give my position on abortion again. But you might gather something of it by saying that, well, the current limit is rather high and a compromise could be reached. I think that's as close enough to telegraphing a position as I can possibly get without actually giving you that position. Let's go to the actual Mississippi law, because it does pay to be informed about what's actually happening. Because this is the law this is the case that has been brought for the Supreme Court to adjudicate on. So, probably is important to understand it, isn't it? So the idea in Mississippi is that most abortions would be illegal, yes, after 15 weeks of pregnancy, which is 2 months earlier than Roe currently, and later decisions allow. Most experts estimate fetal viability to be about 24 weeks. Yeah, I mean, that fluctuates. But again, the question of viability is one aspect of this, because you have to make a convincing moral case for a potential life with an almost guaranteed potential. That is to say, a life yet to be produced, yet to be instantiated, but will if you leave it alone. Why that is so much morally worse or better than a fetus which could survive outside of the womb. This is always the question. Again, it's why these things should be local. Conscience issues should be local. You cannot reduce them to an exact point at which either the religious will say the soul enters the body, or the progressive will say it magically becomes a person, whereas it wasn't before. There is no clear divide here. Viability arguments are... the law was in fact enacted in 2018 by the Mississippi legislature. It never went into effect, though, because there was an immediate challenge against it. Bans abortions if the probable gestational age of the unborn human is determined to be more than 15 weeks, with narrow exceptions for medical emergencies or severe fetal abnormality. It's the doctrine of quite kind of analogous to the doctrine of double effect in Catholicism, which doesn't have a blanket ban on abortions. It does allow abortions as a double effect. In other words, if in order to save the life of a mother, the unborn fetus dies as a side effect, as a double effect, then an abortion is permissible, but it shouldn't be the sole aim of the medical procedure. Traditionally, even states with very strict abortion lines have made exceptions for rape and incest as well. But the Mississippi law is much more generous than that, 15 weeks. Anyway, the state says that the fetus has made important physiological developments by 15 weeks. Abortions are riskier to the mother at this stage of pregnancy. Of course, people who don't think abortion should be restricted don't agree with that. The Federal Appeals Court said that the state hadn't shown any medical evidence proving otherwise, affirming a lower court ruling blocking the law. More than 93% of abortions in Mississippi were performed before 15 weeks of gestation, 14 weeks of gestation even. So, again, it's one of those instances where if you try and centralize a question, or put it as a matter of federal law, or Supreme Court diktat, 93% of abortions in Mississippi were before the age they're proposing anyway. So it wouldn't actually make a significant difference. And all of this hysteria, it's going to ban the right to abortion. No. It's just going to bring the law in Mississippi much closer to what most people in Mississippi actually think it should be, given their own personal choices and decisions. Anyway, why is it so important? Well, recent years Republican-controlled states have passed similar legislation, but these laws have almost always been struck down, precisely because they conflict with the Supreme Court precedent. They were all vying for the chance to be heard by the court. This one, Mississippi's case, has actually made it. In May, the court, with its new 6-3 conservative majority, agreed to hear the case, known as Dobbs v. Jackson. In its brief, the court, Mississippi asked the justices to overrule Roe entirely, and the court's decision in Planned Parenthood v. Casey, which said states couldn't impose an undue burden on the right to abortion before fetal viability. The court will probably not rule on the Mississippi case until June. If the justices were to approve the law, Roe's viability standard would no longer be the law of the land. The Supreme Court has reversed its own positions on various legal issues before. So a reversal wouldn't be without its own form of precedent. Texas, as the Times article here goes on to explain, has actually done quite a legally clever way of doing this. So it bans abortions once cardiac activity can be detected in the embryo. But though this aspect isn't enforced by the state doesn't enforce the law, but it does empower citizens to sue people who break the law, which means that because the state isn't enforcing it, it doesn't actually fall foul of the Supreme Court's verdicts in Roe, which is kind of clever, actually, and an approach more states could take, I think, if this case does fail to produce any meaningful change. As the Times article continues, the Supreme Court refused to immediately block the law, but in an unusual move, justices agreed to fast-track the consideration of appeals from the Justice Department and abortion providers in Texas. And when the court heard arguments on the 1st of November, a majority of the justices seemed inclined to allow abortion providers, but perhaps not the Biden administration, to pursue a federal court challenge. It's not clear when the court would rule on that case. They asked the question as to how likely it is that the court will overturn Roe. After the arguments on Wednesday, the Supreme Court seemed poised to uphold the Mississippi law, the Times reports, based on sometimes tense and heated questioning, and such a ruling would be flatly at odds with what the court has said was the central holding of Roe. Yeah, but the central holding of Roe, as we've established, was flimsy to begin with, and as Ruth Bader Ginsberg correctly pointed out, would lead to these kinds of challenges. So, going back to what I said at the start, you can be in favour of abortion and abortion rights and still think that Roe should be overturned because it's a crap decision. The court's 6 members Conservative majority was divided on Wednesday about whether to stop at 15 weeks, however, for now at least, or whether to override Roe entirely, which would allow states to ban abortions at any time or entirely. I think that's incredibly unlikely to happen. Even if it were completely done away with and states were afforded the right to completely ban abortions, given that the Mississippi case, it could have been posturing, it could be tactics to try and make it more likely to be heard when they say we're not going to ban it entirely, we just want to reduce it to 15 weeks, which is again broadly in line with what people's personal views on abortion are anyway in Mississippi. Maybe that was the reason for it, but otherwise, if you assume that they're honest actors, I don't know enough about the government and the lawyers of Mississippi to make that moral judgment on that about them. But if you assume they're being honest actors, then they just wanted to reduce to 15 weeks, or to have the right to reduce it to 15 weeks. And even if they were given the right to reduce it to no weeks, no abortion at all, they probably wouldn't do it. Largely because, as we've already seen, half of women in America don't want abortion to be illegal. So good luck to any government that attempts to pass such a law. Again, this is why the argument that getting rid of Roe eliminates the right to abortion ipso facto is insane. It has no basis in fact. Trust in your fellow Americans. Trust in your fellow people. Half of women want abortion to be legal, or rather describe themselves broadly as pro-choice. The other half describe them broadly as pro-life. In either case, there's a significant amount of demographic support behind them. Women are an incredibly influential voting base in American politics. It's going to be very difficult for any state government to try and impose a complete ban on abortions against the wishes of half the women in that state. Of course, the polling doesn't track evenly between the states, but nevertheless, there aren't significant fluctuations in this. You're not going to get states imposing things on women that women have no say over or no agency to decide. You can't get states whose governors try and impose these laws without recourse to public opinion will not remain state governors, and the law will be changed. It's just so eminently sensible. There must be an argument against this that I've not considered. I'm sure there is. But I've spent quite a bit of time reading on this subject. I haven't found one yet. But yeah, assuming the three most conservative members of the court, Alito, Clarence Thomas, and Gorsuch, are prepared to overrule Roe entirely, Justice Roberts would need to attract at least 2 votes for a narrower position to uphold the Mississippi law but not overrule Roe, in so many words. But the most likely candidates, who are Justices Barrett and Kavanaugh, said little to suggest they were inclined toward the narrower approach. AOC, incidentally, has attempted to besmirch again the reputation of Brett Kavanaugh by pointing out that a man deciding on the fate of women's healthcare choices has, as she put it, credible accusations of sexual assault leveled against him. Well, if she considers Blasey Ford's accusations against Kavanaugh, as ventilated in that confirmation hearing, to be credible, it does explain why she believes so many batshit mental things. But again, a shameless attempt to overrule the independence of the judiciary by a Trumpian populist of the left, which is what AOC is. There isn't much difference between her and Donald Trump, except that some of Donald Trump's ideas are actually half decent. But what could happen after the ruling? Well, if the court moves to overturn Roe, about a dozen Republican-controlled states already have so-called trigger laws that would make, well, the Times says abortion unlawful almost immediately. Well, no. So, for instance, as times contradicts itself, in Texas, for example, Governor Greg Abbott signed a law in June that says nearly, the word nearly all abortions have become illegal in the state. Days after, if Roe is ever overturned, doctors who then perform the abortion would be sentenced to life in prison. I think the word nearly is doing an awful lot of heavy lifting there. But again, even if it is the case that governors like Greg Abbott attempt to ban it entirely, okay, but then you get to vote him out in 4 years' time, or whenever the next gubernatorial race in Texas is, for which Beto is running, obviously. So if you don't like the law, you can get it changed by voting for it. Democracy is a wonderful, wonderful innovation. Maybe we should try it. Conversely, the Times continues, 15 states and the District of Columbia have laws to protect abortion rights without Roe. Their policies usually bar the government from interfering with the right to obtain an abortion before viability or to protect the health of the pregnant woman. So, states will pass laws reflecting the morality and the conscience of their people. I don't know how many other times I can make that point. That's just sensible. But otherwise, you've just got abortion, serious moral issue, but then you get organisations like Shout Your Abortion, which just exists to extol the virtues of this, which is it. Ugh. Thankful for my abortions. Not all aborted pregnancies were unwanted pregnancies, obviously, that is true. We had 3 abortions, now we have 4 children. Yeah, I mean, okay, that's again not a counter-argument. I made the right choice, my story. Just hundreds, thousands of people. Some of them are quite, they're slightly balanced. You could say morally conflicted. Some of them are not. I have no regrets, for instance. My husband, yeah, whatever. It's just, America, you are an insane country. You are in forced birth. Yeah, that was, there was one more thing I did want to go on to, which is, as National Review points out, you'll see this on Twitter from Democratic activists. The line of attack that they're taking, besides the word healthcare choices, is that denying the women the right to abort a child up to the 25th week is apparently forcing them to give birth. Forced birth, which, as Alexandria DeSantis in National Review points out, is it's a lie, basically. For quite some time, she says one of the most common defences of abortion has been that the unborn child, fetus, a clump of cells, whatever euphemism you prefer, resides in the mother and thus is something akin to her property. The pro-abortion slogan, My Body, My Choice, and some of the women's autonomy arguments for abortion are based on this premise. But it's a fairly easy argument to refute. She writes, the unborn child's existence inside his mother doesn't make him part of the mother in any significant way. Morally speaking, his body does not belong to her in a way that gives her license to end his life. He is an entirely unique, distinct organism with his own functions. His reliance on his mother while still in the womb isn't all that different from dependence on her after birth. A neglected infant will soon die, just as an unborn child will have separated from his mother. It goes on. Anyone who I did philosophy undergrad, I did philosophy postgrad, anyone who's done even introductory courses in philosophy will probably, and ethics in particular, will be presented with one of these kinds of, well, what happens if a person is attached to you on life support? Do you have the right to remove his tubes even though it's causing you severe inconvenience? Obvious analogies with abortion there, but Sanctus is right. I mean, the argument for viability sort of falls down. Certainly, the argument that it's a forced birth certainly falls down, given that, well, actually, newly born children might be viable to survive outside the womb, but not without the parents actually continuing to provide all the sustenance that they were getting within the womb. The unborn child's location then is not a good enough reason to kill him, DeSantis continues, but as the Supreme Court heard oral arguments this week in Dobbs v. Jackson, considering Mississippi's 15-week ban on abortion, supporters of abortion rights turned to another defense, the forced birth smear. Julie Reichelman, the attorney for Jackson Women's Health, alluded to it in her opening statement. For a state to take control of a woman's body and demand that she go through pregnancy and childbirth with all the physical risks and life-altering consequences that brings is a fundamental deprivation of her liberty. Lamentations, Sanctus writes, of forced birth and forced pregnancy cropped up in much of the commentary from the left after the arguments, including from Democratic politicians, pro-abortion feminists, media outlets, and other commentators. But there is an obvious problem with the phrase, she says. For one thing, it ignores the natural connection between sex and reproduction. Humans have been known for all of history that this natural connection exists. The advent of contraception does not negate it. Contrary to the forced birth argument, the overwhelming majority of pregnancies are the result of consensual sex, one natural result of which is pregnancy. So it's not forced birth. It's the conclusion of sex. But it's none of this helps. This rhetoric, the rhetoricization of serious political issues, precisely because you have no legitimate democratic means of solving them yourself, and in particular because people in New York, for instance, cannot countenance the fact that people in Alabama might think differently or be allowed to think differently to them, or have different moral values, or different political values. This is what's ruining the debate. And unfortunately, as long as the Supreme Court continues to uphold Roe, or indeed, I would think I would have to go so far as to say even if it rolls back Roe but to the 15-week limit, but maintains its position as the ultimate arbiter of this matter, as long as the Supreme Court retains this power to itself, this issue will never end, and it will continue to get worse, and it will continue to wreck American politics and political civic discourse. So, to end with where I began, if you support abortion, if you oppose abortion, you should both get on board with a simple, sensible conclusion, which is to remove it from the Supreme Court and defer it to your own people via the democratic process. And if people are disenfranchised by the decisions that are then made, they can leave, cross state lines, go next door, find a state which has laws more akin to what you think of. But otherwise, just don't get an abortion after 15 weeks. 15 weeks is enough time. Anyway, that's enough. I don't think Americans need any more limeys opining on their political psychodramas for a while. So, yeah, that's abortion done. I will abort this recording.